On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
As always, appreciate you coming on to the program. We've got some really good topics to talk about today, as we always do. But one of the things we're looking at, of course, is the protection of animal ag facilities. And, of course, in response to attempts, and numerous times we've talked about this, of activist groups, opposed to animal agriculture, legislatures in several states, including Kansas, over the last 30 years have enacted laws to protect specified livestock facilities from certain types of interference. But Iowa and Kansas have been in the news recently on a couple of different Court of Appeals decisions. So that's the question you ask in one of your articles. Is there a constitutional way to protect animal ag facilities?
Yeah, it's an important issue, Greg, and as you mentioned, it's the Kansas statute actually is the oldest statute of any state on the books, and these statutes, by the way, are not in every state. It's primarily the states that have large livestock industries and large confinement operations, so Iowa and Kansas are going to be in play with respect to that, but it's also in other states too. But Kansas did have the first statute enacted back just about 30 years ago, and the basic idea is to provide some type of protection, at least some degree of protection to livestock facilities so that you can bar access to a qualified animal production facility, and that's a defined term by statute, under false pretenses. In other words, we don't want people to lie on a job application as to what their real purpose of wanting a job at that facility would be. If it's just to get access and they really don't want to work there, they want to try to shield those people away. Well, the question is, how can you do that and comport with the Constitution? So you're trying to bar a person having the intent to harm your business from getting access to your business by employment to then commit illegal acts on the premises. So laws that bar lying and trespass coupled with intent to do physical harm to an animal production facility, the thinking had been, and I've written on this quite a bit in the past, if you've got those two components coupled together, that's probably not constitutionally deficient. Now, laws that go beyond those confines might be. And boy, have we had a lot of activity on this recently.
Yeah, and both towards the pro support and toward against for Kansas specifically, the latest decision on the Court of Appeals was against, or specifically against some portions of the law.
Yeah, there was a U.S. Court of Appeals opinion for the 10th Circuit. Now we're going to talk in a moment about what the 8th Circuit said, which is different. And we may now have a case that's teed up to go to the U.S. Supreme Court because there is some split between the circuit courts on this. But first, the 10th Circuit, which took a look at the Kansas statute, that court construed the Kansas provision that makes it a crime to take pictures or record videos at a covered facility without the effective consent of the owner and with the intent to damage the enterprise. And again, those are all statutorily defined terms. So what you had here was the plaintiffs that challenged this law, as you said, an activist group that doesn't like confined animal agriculture. They claimed the law violated their free speech rights under the First Amendment. And the state of Kansas said, well, wait a minute, what we're barring is conduct rather than speech. And so the First Amendment doesn't apply to that. But the court tied conduct together with speech to find a constitutional violation. In other words, it was necessary to lie to gain access to a covered facility and consent to film activities inside. Okay, I think that's questionable how their rationale with respect to that. But nevertheless, as a result of that, of tying the two together, conduct and speech, the court determined the state failed to prove that the law was narrowly tailored to a compelling state interest in suppressing the speech that was involved that they had tied to conduct. Now, there was a dissent in the case, and when I was reading the dissent, I had to chuckle because that is just about verbatim from stuff I have written over the years on this. And so obviously I think the dissent is correct on this. And it's consistent now with the Eighth Circuit that we'll talk about here in just a second. The dissent said, quote, lies uttered to obtain consent to enter the premises of an ag facility are not protected speech, end quote. And the point of that is that the First Amendment doesn't protect a fraudulently obtained consent to enter someone else's property. And frankly, I think that is the correct view, but this was a 2-1 decision. That was the one dissent, and so they were outvoted.
And you talked about the Eighth Circuit, and this has specifically to do with the Iowa law, but that was upholding their law.
Upholding part of it, yes, that's right.
Okay.
This is where we get the discrepancy. The Eighth Circuit Court of Appeals construed that Iowa statute and upheld the portion of it that provided criminal penalties for gaining access to a covered facility by false pretenses. So they said, look, speech and conduct are not the same thing. We're not going to tie them together. And if you lie on a job application to gain access, and it's proven afterwards that you knowingly lied to get access, you had an ulterior motive, that's not protected speech. And I think that's correct. That's what I have been claiming for quite some time. There's no way that that is protected by the Constitution. Now, what the Eighth Circuit did here on that point, that's the first time that any federal circuit court of appeals has upheld a provision that makes illegal the gaining of access to a covered facility by lying. So they struck that one down. Now, the court held that the employment provision of the law, in other words, knowingly making a false statement to obtain employment, violated the First Amendment because the law was not limited to false claims that were made to gain an offer of employment. They said, well, somebody could exaggerate something, make it untrue, ends up on the job application. It really doesn't have anything to do to get access to do illegal things. It's just you do those things to impress your job interviewer. Those weren't properly segregated, and so that provision is unconstitutional. But the Eighth Circuit did not tie conduct and speech together. The Tenth Circuit did. That's what is now teed up for the Supreme Court if the Supreme Court is asked to and then decides to take a case on this matter.
And just, you had a small note in there, the day, what was it, before the Eighth Circuit Court decision, and that was back on August the 10th. There was another case in Arkansas that is going to go forward.
Yes, that's still out there. And Arkansas is also in the Eighth Circuit, so we have another case that's going to be decided by the Eighth Circuit because the Eighth Circuit determined that the plaintiffs in that case challenging the Arkansas law had standing to bring the case. So that one is working its way through the process right now. So we'll get another Eighth Circuit opinion here one of these days.
I did notice as well that many of these cases that we discussed, plus a couple of others, Animal Legal Defense Fund seems to be one of the main, if not the main, group that are filing these lawsuits.
That's right. They are the primary one that's filing these lawsuits. It's been Idaho, Utah, Wyoming, Ninth Circuit, all over the place. They're the well-heeled group that is primarily the one pushing this.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us on the program this morning. Another thing I know, Roger, that we have discussed throughout the years is the state of checkoff programs for commodities that we have talked about as well. And as you put it, and it's, I think, very apropos, talking about the merry-go-round that revolves again and again.
Yeah, this has been going on for quite some time. Again, this is another one of these almost 30 years where we could reach back more than 30 years of litigation on this. Plus marketing orders, if we want to throw those in. Marketing orders and checkoffs invokes constitutional challenges all the time. And we had a recent case out of the Ninth Circuit again in late July involving the beef checkoff. And really, the case that we go back to on this is a U.S. Supreme Court case in 2005, the Johans against LMA, Livestock Marketing Association. And that is a court case which involved a facial challenge to the statutory language of the beef checkoff that, of course, created an advertising program. And the court said it was government speech. Well, if it's government speech, there's no violation of the free speech clause of the First Amendment. So that really raises a question when we're talking about a checkoff. Is it producer speech, which if it's opposed and producers don't like the speech at issue, they can claim it's a violation of their free speech rights? Or is it government speech, which is beyond constitutional challenge? Well, the answer is it depends. The U.S. Supreme Court laid some markers down in the Johans case, and there are really three elements to the government speech doctrine. And again, I would, as I go through this, keep in mind this is relatively new when we talk about constitutional law doctrines as those go, and it's not well developed. But basically, there are three hurdles. The checkoff has to clear three hurdles to be constitutional. First, the government has to exercise sufficient control over the content of the checkoff to be deemed ultimately responsible for the message. And then the source of the checkoff assessments must come from a large, non-discrete group. And then finally, the central purpose of the checkoff has to be identified as the government's. Now, most of the challenges focus on that second one. Do the assessments, the funds for the checkoff, come from a large, non-discrete group, or are they tailored to particular sources? Cattlemen that oppose the beef checkoff like to point out that that second one is not satisfied because it's them and them only that are funding this. Now, that argument has not prevailed at the Supreme Court. What the argument that the Supreme Court looks at is the first one, and that's whether the government exercises sufficient control over the content of the checkoff to be deemed ultimately responsible for the message. In the Ninth Circuit opinion in late July that was brought by RCAF, again, the challenge is to this $1 per head assessment of cattle that are sold in the U.S. And the USDA Secretary of the Ninth Circuit said is in control of this by virtue of a memo or memos that the USDA Secretary entered into with various states because these checkoffs can be run at the federal level or run at the state level. And so the issue is not the federal level. This originated with Montana beef checkoff, which is administered at the state level through a board. And that's done like that in numerous states. And the Secretary entered into a memo with 14 other states that were involved in this litigation whose state-level checkoffs were wrapped into this. And it was a memorandum of understanding, and the state beef councils had to submit for the Secretary's pre-approval any and all promotion, advertising, research, consumer information plan and projects, any and all potential contracts and agreements. In other words, to make a long story short, the states had to run everything through the Secretary. Now, here's the rub. The Secretary never looked at this stuff, never exercised any discretion. And so, as you can imagine, the cattlemen are upset, saying, look, the states are doing whatever they want to do. The USDA Secretary is sleeping at the switch, never looks at this. And the court said, well, that really doesn't matter. The fact that they had the authority to examine everything and the fact that everything had to be submitted there, even though they're not looking at this at all, that's the key. And so this was deemed to be government speech and not a violation of the First Amendment. Really frustrating to producers that don't like the checkoff. But the court is basically giving the USDA a pass on this, saying, yeah, you've got the authority. We don't care if you exercise it or not. It's government speech.
Translation through all this, this issue is not going away in the aspect
Correct.
that groups like RCAF will still pursue, and I'm sure they have their options or know what their options are, but they will continue to pursue any legal action against this.
That's correct. Yeah, very correct.
All right. One more thing we want to discuss, and it's just as big as the first two topics. of course, concerning the Navigable Waters Protection Rule, and EPA recently announced that they are going to vacate that rule.
Yeah, this is another merry-go-round in the law. We just continue to go around and around and around on this stuff. Of course, the Obama administration came in and put their own navigable water rule in place. And see, the issue on this, Greg, is the Clean Water Act delineates. Well, let me rephrase that a little bit. The Clean Water Act doesn't really define what is a navigable water. It leaves it up to the EPA to write the reg on this. And so when you get a new administration, they come up with their own regulation. The Bush administration had one, Obama administration comes in, they change the rule around in terms of the waters of the U.S. That the federal government has jurisdiction over, and they wrote a very broad rule that farmers and ranchers did not like, picking up ephemeral streams and ditches and those types of things and making it subject to Clean Water Act rules, which says you can't discharge a pollutant into those waters without a federal permit. The Trump administration came in and wrote their own rule and removed a lot of those waters from the government's control under the Clean Water Act. Now you've got another administration that comes in, changes the rule back, is wanting to basically change it back to the way it was prior to the Trump administration. So what we had in this most recent case was an Indian tribe in Arizona that challenged the existing rule. Bottom line, the federal district court, which the case would be appealable, guess to where, the Ninth Circuit, the federal district court said, yeah, that doesn't comport with the statute or the intent of the Clean Water Act. We're going to vacate the rule. The Navigable Waters Protection Rule, which is the Trump rule. That raises an interesting point. And the point is, what does that vacate mean? Is that a nationwide application? Well, if you remember in the Trump years, you had a number of district courts that were vacating the Obama rule, and they did it on a jurisdiction-by-jurisdiction basis, which I believe is the correct approach. We don't want federal district court judges having their opinions apply to the entire country. Only the Supreme Court gets to play that game. And so the thinking here is that the Trump rule is vacated, no longer in effect in Arizona. You default back to the Obama rule in Arizona. Everywhere else, the Trump rule is still in play while the EPA rewrites this regulation. It's a mess, but that's where we're at.
And this could go on. Well, it will go on. There's no doubt about it. It will go on and on and on.
Mm-hmm. That's right.
All right. Roger, sounds good. Hey, as always, appreciate you being on to the program, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.